Commissioner Adira,
Yes, I am here on the line.
Commissioner Kasher,
Here.
Commissioner Wasserman,
Here.
Commissioner Wynn,
Here.
Chair Rumpke.
Here. Thank you, Commissioner Odero, for being able to make it to a phone. Just as everyone heard, there were lots of problems with Southwest, and she was a casualty of the events. But Commissioner Wasserman made it. Thank you.
From a different airport after cancellation night before.
Okay, so we're here. Just as a start, I'd like to talk a little bit about the rewrite project, which we're very excited about here at the agency. We talked about it at some of the prior commission hearings, but last week we did have a webinar to kind of give an overview. And if you weren't able to participate or follow along, don't worry. It will be posted on our website as a live video, not live, but actual video, not just words. I'm looking at Phil. When do you think that's going to be ready to go? Probably soon. So that will be up, so you can hear a little bit more about the project through that. And then, as we talked about at the webinar, our target date for the first draft of the revised act is the first week of August. And again, you can go on our website to find out more information about the project and any revised dates as we go through it. So after that is up, as we talked about, there will be a long period of public comment, 6 to 8 weeks. Then we'll go through a second round of drafting, followed by a second round of public comment, a third round of drafting, and so on. So the goal here again being that we have a product that we are all pleased with, and hopefully all of the participants are pleased with for January to bring to the legislature. Any questions? Yes.
Do we know how many people participated in the webinar?
I think it was 150. Thank you.
Good.
75 were staff. No, just kidding. That is not true. That was a joke. Okay. Any public comment before we get started on the agenda items for something that is not on the agenda? Okay. Seeing none, we have the approval of the May 2016 minutes.
I'm sure I have just one change.
Sure.
It's page 11 of the minutes, which is page 24 of the packet as I have it.
Okay.
This is a discussion of AB 2523. Second paragraph, second sentence. It's simplest just to strike it rather than try to tinker with that. It begins, Commissioner Wasserman asked, and ends with the bill. As it's been pointed out before, these are put on YouTube, and this is not a transcript, so it's better just to strike it rather than tinker with it.
Which, I'm sorry, I'm on page 11. Which paragraph?
The second,
Okay.
so the second sentence there, rather than tinker with that, I just request we just strike it.
Okay, we strike that. It is, again, these are just
Right.
notes summarizing. They're obviously not word for word. No one guaranteed 100%, but the idea
Just simpler than
is someone to follow along. Okay. Any other corrections or comments on the minutes? Is there a motion?
I move to approve the minutes as amended.
a second.
Commissioner Adira,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Rumpke.
Yes.
Motion passed.
Thank you. Okay, next we have the consent calendar for enforcement, items 3 through no, that's not right. Items 3 through 50. And we will be pulling, or I'm pulling item number 4. I understand that the councilwoman has appeared today, but right now she is meeting with the attorney from Enforcement Division on this matter. Just some further discussions regarding the case. But the default matter remains on the agenda. We are just going to let them have their discussions for a while before she comes up and we hear the case. So with that being pulled, do the commissioners have any other items they'd like to pull from consent?
I'd like to pull,
Go ahead, Commissioner Odero.
Thank you. I would like to pull number 3.
Okay,
Thank you.
similarly, number 3.
okay. Any others?
Madam Chair, I'd like to pull 5, 7, 8, and 45. And this is actually to consider, not just to come.
3, 5, 7, 8, and what?
45.
Okay. All of those are pulled. Now, are there any questions or comments regarding the remaining items on the consent item? I'll start with number 6, just while the others. So this is,
You're having trouble with that agenda, isn't it? Too large.
it's too big. Okay, so this is the lift case. And I guess I would just like to have a little bit of a discussion as far as what violations were ultimately agreed upon in the stipulation and the fine amount. Because while I understand that we focused on the failure to timely report, which is a big issue and a big concern, I do note, for example, on page 2 of Exhibit 1 of the stipulation, where it talks about additional misconduct, which I consider fairly serious. And I'm starting with the quarter 2 report, failed to report other payments to influence totaling over 14,000, and the quarter 3 report failed to report other payments to influence over 28,000. There was another issue of failure to do something correctly, wasn't there?
I believe you had mentioned the 6,700 in campaign contributions at the top of that page.
Oh, yes. So, can you help me just understand? And again, I, always say that I realize these are settlements and things are negotiated. But in light of those, and I know there's another stipulation in here where we charge certain things and then we focus on other things as aggravation, and then therefore the fine is increased. And I'm just wondering why that kind of approach wasn't taken here in light of we focused on some violations. We have a fine based on those. And I'm wondering, I guess the real question here to me is this a sufficient fine or should it be higher in light of sophistication and time frame?
Okay. Billy Noes, Chief of Enforcement. Happy to talk about the issues with this case. This actually is a proposed higher fine than typically you would see. As you see in the comparable case of Pasadena Metro Blue Line, the Commission imposed a penalty of, in the California Employment Law Council of $1,000, and typically for reporting problems. The contributions were timely reported by the recipients of the contributions, and so that was taken into mitigation. And the timing of this case, you can see that this was a 2015 investigation while the regulation for payments to influence was being considered. And so this is more of a message saying, here's the payments to influence that were found in this case. We're not charging this as a separate account here. We're charging the reports as we traditionally have, but we're making a note of it in the exhibit to show that we are looking for these and we're considering them. So the fine amount is higher per count for 2,000. Of course, we'll always take the direction of the commission if they would like to see, if you would like to see a higher fine amount for lobbying non-filer cases in the future, or what considerations you would want to take if there's additional disclosure problems. Then of course we'll take that direction. But that was the analysis that went into this case.
Okay, I appreciate that, and I appreciate that it is a higher fine than we have in the past in light of what I would consider aggravating factors as to those other issues. I would think that, especially lobbyist employers and definitely with the issue of other payments to influence, I think it is something we've got to start taking a little bit more seriously. And obviously it is a focus of the commission right now. So not that I think this is an inappropriate fine, and I understand again in the light of settlement and settlement discussions, I'm prepared to support it, but I just kind of want to flag it as something I would have also supported a higher fine.
Good to know.
Anyone else have comments on that one? Okay. Were there any other questions or comments regarding the remaining consent items?
Madam,
Commissioner Wynn?
Thank you very much, and thank you, Ms. West. So on item number 32, it's a failure to file, and it's a default. It seems like the penalty was $3,000 when it could have been $5,000. It just seemed like an egregious case. He still hasn't filed. He's been late many times before, but filed before we actually took an action. And I just wondered if there was kind of anything that I'm not seeing here that resulted in this lower fine. Yes, I know there's precedent that we've agreed to lower fines, but this does seem like a more egregious case than what we have seen in the past.
Right. Harold Tate, the case that we're discussing, the reason that it wasn't a $5,000 fine, and basically the main reason was because his current filing was done, and this is his 2014 filing, and so it's a matter of he said he filed it, he has no proof he filed it, they have no proof that he filed it, and yet he filed his current statement. So that's why we didn't recommend the highest fine.
So he still has not filed this.
Correct.
Is that right? So how often does that happen where we agree to a penalty, but he has not filed, he still works for the state? And I mean, once he pays the fine, is he off the hook? Does he not have to file that report?
Actually, we don't generally follow up, but the clerks do, and they maintain a record and constantly talk to them about this filing. But yes, that is the problem with defaulted decisions, is we don't get the disclosure, and then the higher fine for the lack of disclosure.
So it's a default, he hasn't complied, and you're suggesting 3 over 5. Do I hear 5?
I would have been more comfortable with 5, but I respect, staff, and I know that you work harder at this than I do, and, you have maybe a broader perspective, but I would have been more comfortable with a higher fine. So that's what I would have recommended, so.
Do any of the other commissioners have thoughts on this? I tend to lean towards the higher fine as well. In this case, in particular, because it's a default and we don't have the filing yet.
I think generally the only other consideration I would throw out there is that there have been issues with this filing officer before, which led a little more credibility to his defense. So that I think that also swayed us to not recommend.
But what's the point at this? Why doesn't he just refile? Okay, we get it.
I believe he says principal.
But you're a public.
I don't want to represent for him, but I believe.
Well, you shouldn't have to, but he's not here. So I don't know how much I want to take into consideration something that he's not even here to say himself. The other commissioners?
That was Commissioner Darrow.
Commissioner Odero, go ahead.
Thank you. I support. First, I want to say I definitely defer to the fact finders because other than the report, we really have no visibility. That said, I think that the level of egregiousness of this, and again, I think the fact that there's no filing done, even after getting to the point where we are, I think I agree, and I would have supported a higher penalty, so that we make it very clear, what the issues are that are most important. I guess I shouldn't say most important, but very important to the commission.
Well, and And let me just stress at this point, because it is a default matter, we are able, authorized to raise the fine without any delay in the process. Just so that's kind of this discussion. It's at 3,000. Do we want to make it 4,000 or 5,000? So, Commissioner Wasserman?
Yeah, that notice has been given to the respondent that although you're recommending 3, the commission has the power to go up to 5. So there's no real issue with that. I'm totally in agreement. It is a little bit baffling that he didn't simply file with his explanation and say, look, I did this before, but here it is anyway, but I did this before. So
Yeah, if he had done that when he was first contacted by the enforcement division, would this have been closed, warning letter, or at the very least a streamlined case of $200?
It would have been a streamlined fine, yes.
So,
And he was told that multiple times.
In this particular case, I think that a higher penalty would be warranted. I don't like the fact that he didn't submit the statement. There is information in there that is useful to members of the public to understand and know what decisions he was making at the time that those statements were out there. There's no way of knowing that information without the statement. And that really is the kind of purpose of having those. And without that, I'm not able to make those determinations. So, you know, it's unfortunate that he chose not to file the statement. I really think that he should have. And I think that it's our role to send a message and to let the regulated community know that there are, I mean, there's a maximum penalty of $5,000 here. We're below that. And even if we raise it to 4, we'd still be below the maximum, even given, you know, the severity of this. So I'd be in favor of an increased penalty as well.
And that would give us clear direction if the commission decides to go that route, that what to tell respondents in the future.
and I don't want to diminish the fact that if he has principal grounds or feels that he filed it, therefore he shouldn't have to file it again. But then what we really have is a contested case. And he had the right and opportunity to take it to an administrative law judge if he felt that this was worthy of his principled stance. So, and that's one route. And I understand that's time and expense, but there's the route of just not filing and just not participating is not an appropriate route. So I would, that we're actually just procedurally, this item is pulled from consent if it's not clear yet, item 32, as the discussion, as the discussion continues. And is there a motion on item 32?
Before we do that, I just wanted to say that I'm fine with the penalty as it is, given some of what's there. I do absolutely agree that he had the opportunity to present, you know, sworn testimony, and someone could have determined his credibility as to whether, given what he says he did and the track record of the filing officer, about whether or not he could be vindicated through the process and just take the process seriously. That being said, I'm not opposed to a higher fine, but I'm not inclined to push one forward.
So at this point, is it appropriate for me to pull it off consent or to make a motion?
Well, I just pulled it, so if you want to make, do you want to make a motion?
Well, I'd like to, I'd like to move to increase the fine to $5,000.
I'd second. So the motion right now is to adopt the default decision in order with an increased penalty of $5,000.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. So again, with the remaining items on the consent calendar, any comments or questions for Ms. West?
Yes.
Okay.
I'm looking at 13 to 16, I believe. These are streamlined programs. And could you just comment about these particular cases in general? These are total penalties here are a lot higher than we see in usual streamlined cases, but it looks like it's a bunch of things dealt with at once. So how did we get to this kind of scenario with the streamlined case with penalties of $3,000 and the like?
It's a good question. This is part of the Enhanced Streamline program that we approved last year. And these are campaign statements where you get a base penalty, but you also get 1% in order to find equality and applying Streamline. So then that way, when you have a certain level of activity that doesn't exceed $25,000, you still qualify for Streamline. But we wanted to, the theory behind it was to make it a little more fair to where your fine is increased because you had a level of activity that didn't exceed your qualifications for Streamline, but was more than the typical. So the base plus 1% is what gets you to the higher fines.
Thank you.
Okay, if there are no more questions or comments from the commissioners, is there any public comment on the remaining items on the consent calendar? Not anything that's been pulled, any remaining items on the consent calendar? Okay, is there a motion? If you can clarify what you say. I challenge you, Commissioner Wynn.
So, I move approval of the consent calendars, items, 3 through, no, not 3 through 50. We're gonna say 6 through 50 minus 32, and then 7, 8, and 45. Okay, great. Well, so I said 6.
Oh, you're so good. That's correct. All right.
I'll second that.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
And that we've already pulled 32 out of that as well.
Yes.
Yes.
Commissioner Wynn,
Yes.
Chair Runke.
Yes.
This motion passes.
Okay, now we'll take the remaining items, starting with 3. And I know several people wanted to pull this. I'm just going to start with amending the Enforcement Division and their continued work with other agencies. This is obviously a big case and took a lot of time, but the ability to work with the local ethics agency is obviously always a huge plus. And building those relationships are important, and being able to work together, especially when there's the local contribution limit and our work. So I really applaud the efforts you had on this.
Thank you. The staff worked very hard on this case.
Other commissioners?
I wanted to agree and commend you. It must be, it's a challenge when you can see something that violates what was within our purview, but also violates something else. And being able to partner with the appropriate jurisdictions to see a just resolution must be very satisfying to be commended.
It is. Every commission is different, so it's always interesting dealing with other jurisdictions.
Likewise, I just wanted to also commend your effort on this. This was a job well done. And I do also like the collaboration with other interagency collaboration in the Oakland Public Ethics Commission. That's why I had a question regarding the facts of the case. There's a reference in the staff report on page 1. This is the first line of the introduction, where it references that proactive efforts were made by the Enforcement Division and detected a pattern of activity that led to the opening of the case. I was wondering if you could just elaborate on that.
Sure, I'd love to. Actually, it shines a great light on our investigators. The special investigators, the FPPC, are terrific. They have a program where they identify local jurisdictions with contribution limits, and they use a set criteria that I can't divulge to you. And they look for patterns within those jurisdictions to identify potential money laundering. And then we open those cases proactively. It's very time consuming because a lot of them are not electronic filers. And so there's a lot of Excel spreadsheets. We have a great intern program that we work with the UCs and the CSUs that they help us prepare a lot of the Excel spreadsheets that then the analysis is done by the investigators and also our supervising special investigator, Sandra. She's really the spearhead. Chandra Buckner is the spearhead for this program, and she came up with with the criteria and the program, and she makes sure that it stays effectual and does a great job.
Thank you for that.
Okay, any other questions or comments?
Yes, this is Commissioner Adero.
Go ahead.
Thank you. I wanna absolutely echo the thanks for the good work with the local partners. And I also, now that I understand, I had the same question about what were these proactive efforts, and I'm impressed by that, and I wanna thank you and commend you for truly excellent work in identifying this matter. I do have a few questions, and I also have a comment about the penalty. So to start out, we compare this case to the Dashkin case where there were 12 laundered contributions. I have no idea how many people in that case were asked to act as secret intermediaries. I know that here in this case we have 23 people. I'm just interested in, just for comparison purposes, do you happen to have handy how many people were asked to violate the law in Dashkin so that we can kind of make a comparison?
Dashkin was interesting in that there were a lot of unidentified people that we didn't get to track down because the investigation, we ended up coming to a settlement before we fully investigated everything. So the number of potential busboys and waiters at the restaurant was never nailed down, which is probably why you don't recall what it was from the STIP, because it's approximately this many people. So I would say, even though it says 12, that there were 12 contributions, there was quite a few more than that were pressured into the program or asked to participate in a nice way by their employer.
Okay, thank you. Another question I have is, the memo states that the general manager, Winter, thought the contributions here, in this case, were part of a community outreach effort. Can you elaborate a little bit on what was going through his mind? And to the extent that he told you and explained it that to you.
I can't go beyond the settlement too much since this isn't a default, so the facts are more as presented. But community outreach program, as explained to us, was a proactive program, as they refer to in their press release regarding the case, which is public information, that they were trying to find a way to work with their local officials and increase their exposure to the local officials in their area in a positive way.
Okay. The other question I have is, so the report states that McWane, the parent company, by virtue of being one of the largest manufacturers of ironworks, has a somewhat higher level of political sophistication, and I would expect that to be the case. I'm just curious whether we investigated if McWane has ever been fined in any state or by any other agency for similar violations. I think that's important to really understand the level of McWane's sophistication, which I expect to be high to begin with. I just want to know if we know anything to determine just how high was the level of sophistication.
I don't know off the top of my head, but I do know that the investigators, as a practice, do I don't think we're supposed to say Google searches. I think we're supposed to say internet searches regarding respondents in order to make sure that they're current on any news articles or different information that's out there. So there is a level of due diligence that occurs on cases that I assume also occurred here. And since it's not mentioned, then I would assume they didn't find anything. But those are both assumptions based on practice.
Okay. And then do we know if the general manager was disciplined? We see that McWane investigated, and I see that McWane shared the results of that review with the enforcement division. I'm just wondering if Winter was disciplined for his actions.
That was not shared with us, their personnel action.
Okay. And then finally, I just have some general comments about the penalty. We started out with 37 counts, right? But we ended up with 20. and then we imposed the full penalty as to those. Am I understanding that correctly?
That's correct.
Okay, so is this just a general discount, and that's how we impose the discount that we negotiate by reducing the number of counts, or did we actually eliminate 17 counts for some reason? And I'd be interested in what that reason was and which counts were eliminated.
It's generally the cooperation level. And although I hesitate to use the word discount, it's more in a negotiation of how much effort enforcement has to make to obtain records and to keep an investigation going for a year or two, to interview every witness, as opposed to reducing some of the counts but keeping the laundering fine at $5,000, which is where the commission has given us the direction that they would like to maintain that amount for the violations of that section. So although, like I said, I hesitate to use that word of discount, it is in cooperation to save resources to you, to make sure that the investigations don't drag on for years and years. They're settled in a more relevant time period to when the election was, to when the people are still in office, and it's relevant information.
Until when the business is still going and
The
still
business
may
is
participate in the next election.
Correct.
And everything.
So,
Yeah.
so yes, it is more of that rather than there were evidentiary, there was proof that was found that they weren't contributions made in the name of another.
So, as I understand it, though, it's usually the negotiation is the seriousness of the violation, and this is a serious violation. We don't want to give any impression or precedent that they're going to lower than 5,000 for laundered campaign contributions.
Correct.
But in light of their cooperation, we've combined counts.
Right, and we look at the amount that was laundered into the local elections, and in this case it was $23,900, and the fine being 4 times that amount seemed like an appropriate amount for this type of violation.
I think $100,000 settlement's a pretty good negotiating tactic. Okay, any other questions or comments on number 3?
Yes, Madam Chair. So, as Ms. West had indicated, the commission basically has set forth that as per count, we don't want to go below 5,000 for something as serious as laundering. And the only flexibility you have with respect to entering the settlement is to make these adjustments by account. I don't think I've heard any sort of direction of changing any of that at this point, just inquiries about how that works. Because I think that comes up each time the discretion is exercised. We come back as sort of the oversight, say, okay, how did this play out? You explain it to us, and then we either say, okay, or we don't. So, but appreciate that. I also appreciate in your responses how you've highlighted for us the difference between something that you believe, you assume has occurred, as opposed to what you represent has occurred. And I appreciate that because it's much clearer. Thank you.
Thank you.
Okay, if there are no other questions or comments from the commission, is there any public comment on item 3? Okay, seeing none, is there a motion?
I move approval.
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Runke.
Yes.
Motion passes.
Okay, one item down. All right. Ms. Weiss, are we still holding off on number 4, I'm assuming? Yes, we will until you give me a different indication. And so we're going to go to item number 5. Item 5, questions or comments from the commissioners?
Yes. Just pulling up my. Okay. Item 5. So referring to the bottom of page 3 of Exhibit 1 in support of the stipulation, this is a case involving the public official owning residential property within 500 feet of these 2 parks where over $1 million in improvements is going to occur. My question is simply, and note, even though 75% of residential property in this jurisdiction is within 500 feet as well. That isn't enough to say that the interest of the public official is indistinguishable from the public general. And that's what I get from what's being presented. Is that the position we're taking?
This is an interesting case because there's I think it's Air Force bases around, and so it breaks up the property. And so there was a real analysis done and looking at where the property lies. And in this case, as it says, there are quite a few residential properties within 500 feet of one park or the other, but not nearly that many properties that are within 500 feet of both parks. And so the decision was regarding improvements to both parks. And so that being the case, the significant segment that you look at to see if it's substantially similar is that of being affected by both parks improved at the same time. So the segment of people that are affected by this, since you are talking about millions of dollars of improvements, is very limited. So that the exception has to apply in a broader term.
I see. That's why I need the clarification, because as I read, my interpretation was that the facts were that 75% of the residential property was within this overlay of both of these properties, not being familiar with the location myself, unfortunately. So what you're saying actually is 75% of the residential properties in this jurisdiction are within 500 feet of one or the other, but we're talking about a decision maker who is within the overlap, and therefore it's a much smaller slice. Okay.
Correct. And it's an affirmative defense, so it's a burden of can he prove that and to any reasonable degree. But we actually assisted a lot with this part of the analysis in order to help him understand how it didn't apply.
So it sounds like it was a little more difficult analysis. I imagine that probably went into some of the mitigation questions about what's going on, but at the same time, you determined that it was pretty clear that this was a problem that should have been addressed ex ante as opposed to going forward and voting and having this come around later on. But I appreciate the clarification, because when I saw that and I thought, I was going to start asking, well, at what point do we say the public generally, if 75% of the public generally is affected? Since that's not the case, totally clear now. Thank you.
Thank you.
Okay, any other questions or comments on number 5? Public comment on number 5. Seeing none, is there a motion?
I move approval of number 5.
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Runke.
Yes.
This motion passes.
Okay, number 7. Streamlined case on lobbying report non-filer. Questions or comments from the commissioners?
Madam Chair, I made an error when I was moving things about. I meant to actually pull just 8, not 7. So
Okay, so are there any questions on number 7? Any public comment on number 7? Is there a motion?
I move approval of item 7.
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
yes.
Commissioner Wynn,
Yes.
Chair Runke.
Yes.
This motion passes.
Okay, number 8. Commissioner Wasserman.
Okay, let's make sure I've got the right one here. In the matter of Carlos Villapuerte, I'm going to refer to page 3 of the Exhibit 1 in support of the stipulation. And the question here, we're looking at the second paragraph from the bottom. And the question is, how much involvement does a public official have before a ballot measure committee becomes a controlled committee? And the reason I ask this question is past experience out there and things like school board members jumping up to be really involved in a pro-school bond measure campaign. And I note that these were not the people who set up this, but there was a certain level of involvement set forth in the exhibit. In terms of you know, us taking a look at what's going on and providing direction to you, where is that line? Obviously, you're going to say it right here, but
Well, right here.
yeah.
But, no, actually, it's a very good question. It's a constant question that we're faced with. And it comes from the act itself. There is a definition within the act of control committee, and that's when you have significant influence over the expenditures of the committee. And so the act focuses on the expenditures, but over time, it's also, there's a second half that has any kind of control. So you look at this case, and this case is easier than a lot of them because it is expenditures. And when you have control over the expenditures, there's no real temporal element in the definition. It's when you exert that control, it becomes a control committee and everything that comes with that. So what's interesting about other cases is that sometimes it's not expenditures, and so you're looking at significant influence over the actions of the committee, and it becomes more of a more difficult question. And so hopefully there are plenty of advice letters out there. In fact, there's a terrific one written by Hyla Wagner that I rely on a lot. And so over the years, it has evolved to where there's a lot of definitions given and advice and direction and advice letters. And hopefully next year, the commission will adopt a reg on it. but that's an enforcement dream. And but for this case, it's a relatively easier analysis because expenditures is in the definition of control committee, and it makes it an easier analysis of significant influence.
And 75% of the contributions were from these individuals, right? Or roughly, I guess that's the board. So.
Right, contributions, it's a factor, and we do look at it. But yes, a majority of the contributions did come from them.
Okay. Any other questions?
I think that's fine, except for the last question I had on that was about the joint and several liability or separate. I may have skipped. It says for similar purposes, each respondent accepts 1/3 responsibility for this. Is that a moral acceptance, or is it an actual, they're going to pay 1/3 of the fine each, or joint and several?
Well, as you can see, that's a carefully worded statement.
Yes.
For settlement purposes, the respondents in this case, because as you know, enforcement just is a proponent of joint and several liability. That is what we're given in the statute. And so we don't assign blame unless you're liable or not liable for a count. So in this case, the respondents wanted to assert how much blame they are each taking, or how much responsibility for the penalty that they're all taking. And so for settlement purposes, they're all accepting 1/3 responsibility each.
But in terms of the actual fines, that remains a joint and several in this case.
It does remain that, but it is paid in full.
It's just of interest to me who actually ends up paying the fine. I'll leave that at that. But thank you.
Okay, any other questions or comments on number 8? Any public comments? Seeing none, is there a motion?
I move approval of item 8.
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Rumke.
Yes.
This motion passes.
Okay, number 45.
Okay. Do I have the right matter? Is this in the matter of James Larry Minor?
Yep.
Okay. So we had a discussion on a different matter about what this commission might think is an appropriate penalty. In that case, for someone who had defaulted and basically refused to proceed. In this case, we have a public official who had 3 bites at the apple at 3 different opportunities for disclosure. The original Form 700 in each of the calendar years 2012, 13, and 14 was amended, and then subsequently amended again. In my view, 2012 and 2014, the end result disclosure amended in 2015 was substantial in difference between the original filing. But then by comparison, 2013 was over $100,000 category that was added in from 0 to 499. So from my perspective, in light of some of our discussion about the filing and the importance, I would really be, I know this is a settlement, I know it's negotiated, etc. But in my case, I would really hold this person to a higher fine on this. And perhaps you might want to discuss what the factors of mitigation were. I know they're set forth, but perhaps you could elaborate further because I'm not there.
Sure. As you know, we use comparable cases, and traditionally, if you fall out of streamlined SEI non-disclosure, your typical $100, $200, $400 fine, then your standard SEI non-disclosure fine is $1,000. The commission doesn't really deviate from that much. In fact, before the hearing, I made sure that I pulled the last 4 or 5 cases just to make sure. And generally, the commission's direction has been we don't waver from that unless there's a conflict. So if there's a conflict, the fine goes up in coordination with that conflict, then we see that it caused some behavior. And in this case, as we said in the exhibit, we looked and made sure that there was no conflict, and going through all of this obviously took quite a bit of time to double check and triple check, and we felt comfortable. And what we did instead in this case, since $1,000 was the typical fine for situations of non-disclosure on SCI, what we did instead was then count each SCI for the 2 different positions. And so in that way, the fine is almost $2,000 per year. Because, well, it is $2,000 per year. That's how math works. But it's the $2,000.
Thank you for that.
And it's $2,000 per year, and because we charged each board for each year, so there's a lot of overlap on these 2 boards, and so it could be argued that you could charge just the combo of both for $1,000. But in our opinion, it should be charged for each board that he is on. So then that way there was $1,000 for each board per year, which gets you to $6,000. So since we felt like the comparable cases the commission has given us over the years, it's $1,000 for these types of violations, we felt the mitigation of he attempted to remedy it himself, and then we assisted him from there, that was the basic mitigation that was in the case, but it didn't outweigh the fact that we wanted to charge for each statement per year. And that's how it still looks like $1,000 account, but you have each jurisdiction being charged separately.
So as a follow-up to that, make sure I'm clear. The commission has basically expressed a preference that if there is this an additional conduct, then that would be an aggravation, and that would raise the fine. Do we have we considered this type of scenario and consider whether that would be an aggravation where one is filed and then filed again, and then only with our assistance come out with actual, we hope, full disclosure?
Generally, there's no middle amendment. Most people, the reason that their disclosure is correct is because we have assisted them to get their disclosure to be correct. There's not generally a lot of people that have an epiphany and file an amended disclosure with the correct disclosure on it and then end up before you. Usually when people are amending, it's because they remembered a gift and they just added it, and it's not a case that would come before you. So there's any of the cases that you see, including the ones that are on the agenda today, there has been some assistance to get to the point of disclosure that we're at today. So that's not unique. And it just in terms of he didn't get it right when he did it himself as opposed to when we did it then.
Which is what I'm getting at is the difference between saying this behavior, which is generally what we use to consider as aggravating in terms of the offense, versus something that we don't usually deal with, which in my opinion, separately, is aggravating, which is my opinion, and my opinion may be alone, but I just want to make that clear because I appreciate what you were telling me about what we've considered in the past as an aggravating factor. And then I guess one has to consider whether this scenario would either be aggravating or mitigating. Aggravating because he had another bite of the apple,
Right.
added in 58 investments in real property, yet didn't adjust his gross income received from 0 to 499 to 10,000 to 100,000. Or we say, gosh, he really tried and we got closer to disclosure. I'm falling on the harder side of that line right now. But thank you very much.
Okay, any other questions or comments from the commissioners regarding item 45? Commissioner Odero, anything from you?
No.
Okay. Is there any public comment on item 45? Seeing none, is there a motion?
I move approval of item 45.
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
No.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so that is it for the enforcement matters. But for item 4, I see Ms. Castillo is up here, and I think that you guys are going to take a 5-minute break. Is that correct, Ms. West? That would be very helpful. Thank you. So they're going to take a 5-minute break so that they're on the same page and updated, and then we'll call that matter. So we'll call that matter in 5 minutes. Any questions regarding the items going to the ALJ for Ms. West before she steps out? So that's items 51, 52, and 53. As you know, these are recommendations to send the cases to an ALJ because they were unable to settle. The commission doesn't have to take any action if we agree with the recommendation. If there are no questions or comments, those 3 will be moved as recommended. And we will, thank you, Ms. West. We'll move on to the regulation while you step out. When you come, when the regulation's over, we will take up item 4 one way or the other. Yeah, you might get more than 5 minutes. Okay, so we are on item 54, the proposed regulations.
Good morning, Chairman and Commissioners. I'm Lynn Rodriguez, Senior Commission Counsel of the Legal Division. I'm presenting for adoption proposed amendments to Regulation 18239 dealing with the Act's lobbying provisions. Staff proposes these amendments in order to increase transparency and public disclosure by encouraging compliance with the Act's lobbyist registration and reporting rules. We believe these changes are necessary because of the increasing use of sophisticated lobbying techniques by shadow lobbyists or those who seek to evade or obstruct the law. So while the practice of lobbying has evolved, our regulations have not kept pace with increasingly sophisticated techniques. These factors, combined with a largely self-regulated industry, provide little or no incentive for individuals to comply with and abide by the rules. So staff held an interested persons meeting in June to solicit public input on the proposed changes. Some changes were made to the regulatory language in light of questions about whether the proposed changes apply to in-house employees who lobby, and also in response to questions about the presumption itself. Staff has clarified in the memorandum and the revised regulation before you that the rebuttable presumption applies only to contractors who lobby. We did receive a comment letter from the Alliance for Justice proposing more explicit language stating that the presumption does not apply to employees. We also received a comment letter from the Political Attorneys Association detailing due process questions raised at the interested persons meeting, as well as a comment letter from a former FPPC Commissioner Ronald Rotunda. I'll briefly address some of those issues raised. Now, based on those letters, there appears to be some misconceptions about what the proposed language does and does not do. First, I'll address what the proposed amendments are intended to do. The proposed amendments specify situations giving rise to a rebuttable presumption that certain payments made to an individual are for direct communication with a qualifying official for the purpose of influencing legislative or administrative action. This rebuttable presumption affects the burden of producing evidence. It is triggered only after Enforcement Division establishes the following: that an individual receives or is entitled to receive compensation from a client for services that include direct communication with a qualifying official to influence legislative or administrative action. The compensation is $2,000 or more. The compensation is for services in a calendar month. Once these basic facts are established, it could be presumed that the entire payment was for direct communication with a public official, unless the respondent offers some information to rebut the presumption, at which point the presumption no longer applies. Now, this burden of production is a low threshold. It's a good faith showing, if you will, to determine if a case is worth pursuing. It can be based on testimony or any other information that would have a bearing on the facts that established by enforcement. It is not overly burdensome. On the contrary, individuals engaged in direct communication with officials should already be tracking their time and compensation if they are in good faith attempting to comply with the lobbying provisions of the Act. That's because they need to know this information in order to determine if they meet the lobbyist registration threshold. So the respondent provides a good faith showing of information, the bubble bursts, and the presumption does not apply. The finder of fact must weigh all the evidence and determine, based on the preponderance of the evidence, whether a violation occurred. Now I'll go into what the proposal doesn't do. And the proposed regulation does not do is change or expand the legal requirements under the Act for registering as a lobbyist. It does not apply the Act's lobbyist registration and record-keeping requirements to individuals who do not qualify as lobbyists. It is not a reverse record-keeping requirement. Individuals who are engaged in direct communication with qualifying officials already have a duty under existing law to keep track of their time and compensation to ensure that they are not reaching the lobbyist registration threshold. It does not require anyone to prove his or her status as a non-lobbyist. And I emphasize this because the comments that we received use the term prove numerous times and mischaracterize the proposed amendments. We're talking about here is a minimal burden of production. It is not a burden to affirmatively establish a fact. The rebuttable presumption does not shift the burden of proof onto the respondent. That is enforcement's burden and their burden alone. Also, the presumption does not apply in a criminal action. The presumption applies in administrative and civil proceedings. The due process concerns in case law cited by CPAA and others have specific application in criminal cases, but there is no administrative or civil law analog, so it's not applicable in this context. And lastly, this is not a unique or unusual presumption. And contrary to some of the comments received, courts, including the U.S. Supreme Court, have held that administrative agencies are entitled to create evidentiary presumptions. And these presumptions are traditionally accorded considerable deference. Commission regulations already contain numerous presumptions in other areas, including the campaign and gift rules. And this presumption is similar to the types of presumptions that appear in regulations of other state agencies, including the Department of Toxic Substances Control and the Bureau of Equalization. In summary, what the proposed amendments do is encourage individuals to track and monitor their activities. Again, things that they should already be doing if they are in good faith complying with the Act's lobbying provisions. It encourages compliance with the Act's lobbying registration and reporting requirements, which provide disclosure and transparency. And it provides enforcement with an appropriate tool to vigorously enforce the Act and increase administrative efficiency by allowing them to assess and dispose of matters that are routine and non-meritorious complaints earlier in the process. So staff recommends the commission approve the proposed amendments to Regulation 18239.
Thank you, Emmeline. And Dave, just say your name, perhaps, and anything you have to add.
Yeah, Dave Bainbridge. I'm the Assistant Chief of the Enforcement Division. Just wanted to give a little perspective on how enforcement sees this reg. From a practical standpoint, what we foresee happening is that people who are being paid to try to convince public officials by the persons paying them will begin or have a requirement that they keep records. So they'll be tracking their time, they'll be tracking what they're being paid for. The benefit to them is when they do that, they will know if they're getting close to the $2,000 threshold, it would then qualify them as a lobbyist. By having these records available, they will have this information and they will be better able to comply with their legal requirement, which is if they hit this requirement for the month of $2,000, they have to file as register as lobbyists, file reports, and they may have to take a few people off their Christmas list. The other advantage to them would be if there is a complaint filed against them with the Enforcement Division, we send out a letter of inquiry. They come back to us and provide us this information that shows that they were paid for other things. It wasn't just for lobbying. That's the end of the case. We close the case. There's even no investigation. There's no case. That resolves the matter at intake. That's where the efficiency comes in from our perspective. And that's why we believe this is a good regulation. I think it would just make the process more efficient and it would actually eliminate non-meritorious cases for the most part.
All right, thank you, both of you. Good presentation. Any questions from the commissioners before we go to see public comment?
This is Commissioner Odero. I have a question.
Sure, go ahead.
Thank you. So if the burden is a burden of production, what exactly, well, maybe not exactly, but what would be sufficient since the presumption can be rebutted by testimony? What would be sufficient to rebut the presumption? Because the memo on this says, it says, once the basic facts are proven, it would be presumed that the payment was for direct communication unless and until the individual offers evidence, which we know also can be testimony. And then it says, if the individual offers sufficient evidence to rebut, the presumption is disregarded, and then the competing evidence must be weighed. But so what is sufficient evidence to rebut? Doesn't that convert the burden from a burden of production to a burden of persuasion? I'm confused. I'm hoping you can clarify for me.
If the burden of production is a low threshold, it could be anything. It's a good faith showing. So it could be testimony. It could be a written statement saying, I was paid for other services. So it is a very low threshold.
This is Commissioner Chair Rumpke. Commissioner Odero, the law states it this way, and again, it's not as precise as you may like, but it obligates a party to introduce evidence sufficient to avoid a ruling against themselves. So, in other words, you have to step forward with, as we're saying, some evidence, good faith evidence, sufficient evidence that the trier of fact is not going to automatically rule against you. So what is that weight? Again, you're not proving anything. You're offering something that puts this into a contested matter.
Okay, so then this sentence of the individual offers sufficient evidence to rebut, it's still not, no one's going to be making a determination of whether that is anything beyond a statement, correct? I think this, I support this. I just want we're not forcing someone to prove anything in order to rebut. All they have to do is make a statement.
Correct.
And then go into, okay.
And it's correct. Testimony is sufficient, as you point out, because testimony is evidence. I think the discussion that staff is bringing up is more along the lines of best practices. You can always rely on your own testimony, but then you also have to rely on the fact that it's going to be deemed credible by the trier of fact. Often, even here in cases and complaints, as you know, we have people who come in and just provide their word against the evidence, and it's up to the enforcement to decide whether it's sufficient to proceed or not. In these cases, once the presumption is put into place, again, testimony will be sufficient if that is in fact what the individual wants to rely on. Again, best practices would be to be keeping some kind of record or monitoring your activity as is required under existing law if you are going to comply with the law. I mean, I think we're going to have some public comment, and I guess the flip side to this is if you are not tracking payment for services, how do you know you have not hit the threshold of $2,000 a month yet? So that's, again, it's logical, and that's part of a presumption, a logical inference from the facts. So the other commissioners are, Dave?
Yeah,
That I wasn't disputing.
No, I know you're not. I just, I'm commenting on letters.
Okay. Well, thank you. I appreciate the clarification.
And I was just going to add to that point. That's why the list is there in the last sentence of the proposed regulation. We wanted to provide guidance to people who could potentially be regulated as to what sort of evidence that we would be looking at that would help to prove that they had been paid for other reasons.
It's a helpful reg. Commissioner Wasserman, you had something to add?
Yeah. First, I want to say thank you very much for addressing those issues. Also, for both of you being here to address both the comment letters and also some insight as to how the rubber would hit the road. I actually had some of the same concerns as Commissioner Darrow, and I think I still do. Because I think about this, and if in truth, whatever contact I'll use I as just an example, but the person has that is truly incidental, and they consider incidental and therefore not even really worthy of tracking beyond anything, they might be able to say, well, here's my phone records redacted to show you something that here's my one call that month to that office. But that doesn't really tie into a dollar figure. Maybe that one call is worth $2,000. I don't know. Maybe someone is worth that in what they do. But you know, the idea that then on the flip side that I could simply say, I declare under penalty of perjury that no, I'm not receiving compensation to do those things, and then this would all go away. Doesn't seem like what you're really trying to accomplish there. I mean, I understand you're trying to streamline on the intake as well, but it cuts both ways, right? Either testimony is not going to be sufficient because it's going to be determined not to be credible, or even documents produced about billing records or internal credibility determination is very important. But on the flip side of that, if it really does eliminate the whole investigation with its meeting a burden of production, then I'm not sure how it actually tightens things up. You see what I'm saying? I hope. Okay. Thank you for that validation.
Well, it is just to encourage compliance with the Act's reporting and lobbying provisions. And it is a low threshold. So if you respond or produce some information, the presumption goes away. But it also allows enforcement to determine whether a case is meritorious or not, and to proceed. And if it's a contested case, then it's up to the trier of fact to weigh all that.
So what you're really saying is that the presumption may go away, but if enforcement feels that there still is a valid case here, they no longer have the presumption to work with in their favor.
Right,
presumption goes away, and they just have to prove their case.
right.
Whereas the submittals are very concerned that that presumption will not go away because the determination about credibility or whatnot will, from our side as the agency that is also enforcing this, that we will determine, well, that's not credible, and therefore try to maintain the presumption. So, but that's not the case.
That's not
Produce,
the case.
presumption goes.
Right.
I think it's, this Tyler Wagner, just the presumption's trying to make it so respondent is not in a better position saying nothing than participating and providing some relevant information. You know, it's just versus providing no information. Here they're required now to provide something, provide some testimony saying what I've paid for.
And I think it's also, as Mr. Bainbridge said, it does provide guidance in an area where it seems to be lacking. Again, the law as stated is the $2,000 a month for direct communication. That's not us, that's the law. How do we interpret, enforce, and have individuals comply with that law? And this definitely, I think, goes a long way in providing guidance and a reminder of the obligation to be aware of the law and when you hit that threshold. Other questions or comments from the commissioners?
I have a
Commissioner
comment, but I'd like to maybe save it until after, if there's testimony from the public on this.
Likewise.
Okay, let's, is there any public comment on item 54? I know we had letters submitted and perhaps they are standing on the submitted letters, which may be the case if I don't see anyone come up in the next 5 seconds. Okay, commissioners, any follow-up?
Yes, I have a comment. First of all, I want to thank staff so much. The report was very well done and very complete, and it actually helped us evaluate the letters that came in because I was able to go back and read the staff report and kind of see what had happened at the interested persons meeting. I do think shadow lobbying is a problem. It creates an unequal playing field. It keeps information from the public that they're entitled to, and it undermines public confidence. So I think that this is a really great first step, and I think it's a low presumption. And you're right, people should be keeping track of this anyway because there's a law in place. So I want to commend staff and say that I support your recommendation.
Okay, Commissioner Kasher?
Yeah, I also wanted to thank staff for this. This was a really interesting reg. I had to take my attorney hat off because part of me was thinking, well, you know, I reflect my time to the 5 minutes, you know, and you could
as
just,
we talked about
yeah,
a lot.
and you could just
everyone,
produce those and be able to, you know, pencil it out and run those numbers and figure out whether or not you're over the threshold. But I also know that lobbyists tend not to reflect their time in that way. At least not all of them do. And sometimes they're paid a lump sum for an outcome. And it would be hard perhaps to determine whether or not you're crossing that threshold. But I am given comfort by how low the standard is and that if testimony of the individual would be sufficient, sworn testimony perhaps, because it would be, that would be important. So that gives me comfort. I was also intrigued by some of the constitutional arguments that were presented. I didn't have a chance to delve into all the U.S. Supreme Court case law, but I am
Talking about criminal cases?
right. That's not my expertise, but I am persuaded by staff's position, and I think that's correct. That a lot of the cases that were cited were in the criminal law context, and this is, you know, we're talking about administrative hearings, civil actions. So I think that's the right call on that, and I too am supportive of this. So.
Okay, any other questions or comments? Hearing none, is there a motion?
I move approval of this recommendation, this regulation.
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Runke.
Yes,
This motion passes.
thank you. Okay, we are going to jump back to the enforcement matters, in particular item 4. Again, just to set the stage, the item is before us as a default matter and a request to accept the recommended default decision in order, but as we know, the councilwoman did submit a response, or I'll say a letter, asking that we not enter it. But then there has been further development.
Good morning.
Please state your, yes.
Good morning. My name is Bridget Castillo from the senior attorney from the Enforcement Division. And we have reached a tentative agreement for 12 counts at $55,000. And we'd like the opportunity to bring it back in August.
Okay, you said a tentative agreement for 12 counts at 55,000. I guess, and I'll speak for myself first, and then we can hear from the other commissioners. If this is the route we're prepared to go, because at this point, I mean, again, I was prepared to accept the default decision in order based on the history of this case and the lack of participation for quite some time. So I would want stated on the record and agreed to by the councilwoman the broad facts and broad terms of the settlement, so that we don't find ourselves in a situation in 30 days that this is not what's been agreed to. I don't know how we, because once it is stated on the record with sufficient facts or the violations and the fine, it would be an enforceable settlement from our point of view. That's my position.
So I guess my question related to that is procedurally, are you asking for us to continue this default proceeding to the next commission meeting with the option of adding in an alternative stipulated settlement, or are we asking to settle this today? Because I think the other time that we did something like this, we had someone here with a check to lock
Right.
it down and sign off on the stipulations.
I think
It
it's
doesn't sound like we're as far along as that.
now, my understanding is you're asking for a continuance based on a tentative settlement. And I'm just, before we would grant a continuance, my position is the settlement should be firm enough that there is not a doubt to it. Otherwise, I'd rather discuss the default and proceed on the default. So that's my position. But if we feel confident enough in the settlement that we'll see it next month with check in hand, then I'm happy to go down that route. Does anyone else have comments on that?
Well, I'd like to hear from staff, and I, as a rule, I defer to staff because you do this every day. I was prepared to accept the default. I do see the benefits of a stipulated settlement. So if you are encouraged that this will in fact be settled in 30 days, I would be willing to grant a 30-day, extension. I don't want to put you on the spot like it's a guarantee, but you've been involved in some
for the
conversation.
past couple hours. Galena West from Enforcement, and we do encourage settlement. We encourage settlement not only because it takes the burden off collections, but also it gets the amendments and disclosures. Ms. Castillo has talked to Ms. Baco Del Rio, and all the amendments either have been filed or will be filed by the next commission meeting. And there would be a settlement in hand where there's an agreement where Ms. Baco Del Rio will also get to have a couple statements where she expresses her understanding of the accounts and her side of the story, so to speak. So we always do encourage settlement just for those reasons. In order, when people participate in the process, they do get to say their side of the story within reason and truthfulness, and so that's why we do encourage the settlement with the disclosure and
The acknowledgement of wrongdoing.
the acknowledgement.
But just, I guess, from my point of view then, so you're not concerned as much about putting the terms of the settlement on the record, because if I procedurally understand what you're proposing is that the default decision in order remains pending?
Yeah, I guess that the question is that
That's
by
our
continuing the
alternative.
matter,
Yeah.
are we still in a default position? We've not given up anything really, other than some time.
Okay, correct.
The only thing would be the question is based on sort of the tentative direction it's going, this commission might not want to put it over if we think that number is way out of line for what we, as some of us may have been prepared to vote on today. So perhaps that direction
That would be the
See,
question for the
if we were
commission.
willing to get that, because the other problem with us giving that direction is sort of ties your hands a little bit. But procedurally, we would not be giving up our default power over this respondent.
Because we generally don't talk about terms of the settlement before we present it to you, but this is the unique case of you would be pushing the default over to the next month. And so you should know what terms of settlement would be presented to you as an alternative to see if that's palatable at all, because it wouldn't change between now and then.
Well,
Yeah, I think, in my point of view is you can always enforce a settlement, but I guess the better route would be if it's not, agreed to by next month, we go with the default route. So that's even a better approach. So so 12 counts, $55,000. Can you give us an overview of what the counts are, what's been dropped?
So all the mystery would be gone.
but that perhaps is, well, you can go ahead and do it after that, or?
I would just say that the one that has been in contention of the 4 personal use counts, one would be dropped, and that there was some question that we had been asking for documents, and so we would get some assertions to make us feel comfortable dropping that. And then the 24-hour reports would be consolidated, and in order for us to come to our 12 counts.
Okay. So 12 counts, $55,000. The proposal is to put this over for 30 days. Okay.
This is Commissioner Ardero. I just have a question and hope that somebody can clarify. And along the lines of what are we giving up here by taking this procedural step? Our statement of we're willing to continue this with the default pending, but we understand that there's an agreement of 12 counts by 55,000. We are not giving up the ability to then, when this settlement is presented to us in August, to debate the settlement amount, take it off the consent calendar, debate the settlement amount, and make a recommendation if we so desire that the amount be different. Correct?
Correct.
We're not being bound by this amount at this point.
Correct.
Okay.
But we know it's fair to say this is the baseline.
It's fair to say this is what you'll see.
But once we see it, and once we see it with the facts, I think the issue is if we feel it's insufficient or we have concerns at any issue, we still have 100% authority to reject the stipulation.
Right. That's my interest. I'd like to see the report and the summary that the Enforcement Division will provide to us next month without waiving any rights that we have under normal circumstances.
Absolutely agree, and that is the process.
Great, thank you.
Any other questions or comments, or this matter will be put over until next month?
I have one comment, and that is basically just to give you some insight of where I'm going to be then next month, is I'll be particularly looking at these personal use prohibition counts, and trying to see, whether what's comes up, if we're going from 104 down somewhere else, how far we really are going down. I'm not saying that I'm jumping up for this 55. And who's going to pay those? Because we have this base penalty against her individually versus against committee, etc. So I know it's difficult to deal with a respondent whose expectation made, well, I'm going to get this continuance based on this particular number and think that that's a done deal. But I think it's been emphasized we have our options beyond that. So thank you.
Okay, if there's nothing else, thank you, and we'll discuss this matter further next month. Thank you. Okay, item 55, the legislative update.
May I start?
Yes, please.
Thank you. Commissioner Philippong, Legislative Director.
Before I begin, I do want to update a few positions under the recommended positions because there's been some movement over the last 10 days. Starting with item number 1 on Mendoza, I'm asking that we move this to August. The bill was gutted and amended earlier in the month, and it was gutted and amended at a time where after all of the committee hearings are supposed to have ended, so we're not even sure if this bill is going to move. So there's a number of variables in the process that we just don't feel comfortable at this time. And August, we believe, or I believe, is enough time for us to engage in this bill. On item number 3, on 2318, I'm asking that we amend the staff recommendation from opposed unless amended to neutral. Since the agenda item has come out, the author and the sponsor have showed a good faith effort in addressing the issue by submitting amendments or requests of amendments to Legislative Council to address the issues that we brought up, and we have no reason to doubt their honesty because throughout the process they have worked in good faith and taken essentially every amendment that we've asked them to take.
Commissioner Wynn?
Thanks very much, Mr. Ong. This was the one that was really giving me heartburn because we've all been reading about this in the press. You know, there's been so much activity around the Coastal Commission.
Oh no, that's another bill.
I'm sorry.
I'm talking about item number 3.
Sorry.
That's okay.
You went from 1 to 3.
Yes.
Okay.
I'm sorry about that.
Sorry.
I'm just updating you on the changed staff recommendations at this time. Had me worried that there were articles about this bill that I didn't know about. And so on that bill, we asked that we remain neutral, and we're happy to report back in August. When the
And just
amendments
for
are
clarification, so the proposal that they're offering right now is to move out the larger issue of public,
use of public resources by nonprofits,
keeping it where it is an existing law.
right? Which
Giving
is
us-
50,000 of the government could have, yeah.
Yeah, and just giving us the more narrow authority that
That's right.
was with the FTB.
That's
Okay.
right. It deals
Thank you.
directly with campaign filings.
Right, the forms and
better
making
fit
it
for
like
us.
multi-purpose organizations
That's
now. Okay, well, I'll just, since we're talking about, I'll just say that I really appreciate the author's office working with us on this. We have had lots of suggested amendments, but I think if we get to this point, it's the best shape it can be in, so that's great.
And then the last bill in the recommended section, item number 4, AB 2523 by Mr. Mullen. Rather than a neutral if amended, I'm asking that we just go neutral. The amendments have been received from Legislative Council, reviewed by staff, and submitted to the Appropriations Committee to be for the bill to be amended when they come back in August. And on that bill, I want to thank the author's office, especially for engaging with us after our position came out a couple months back, and thank Kyle Wagner and Matthew Christie of the legal division, who spent a significant amount of time drafting amendments for that bill. So, but we're happy to go neutral on that bill as well.
So just so
Or
we're
proposing
clear,
neutral, sorry.
right, so just so we're clear, on 1, 3, and 4, it's basically, well, there's 2 no recommendations and there's 1 neutral.
Yeah.
So, because the only one we don't really have to take a vote on that we just discussed is Mullen, because currently we do have an opposed unless amended position. So that one, if the commissioners were so inclined, we would need to make a motion to move to neutral on that. So, and again, I think the report summarizes it pretty well, and I agree that I appreciate the author's office working with us. The biggest issue always was whether or not the issue was going to be in the Political Reform Act. They moved it there. We had some ongoing issues regarding implementation, which they've listened to, and I think that's the latest.
That's the latest, yeah. They've taken a number of conforming requests that we've asked for, and there's a lot of process-related issues with the difference between jurisdictions who fall under default enforcement by the FPPC and those who adopt their own limits, and what happens to the relationship with the FPPC.
So just on, it's kind of a difficult procedural way to figure out the best way to do this, but let me ask, do the commissioners have any questions on 1 or 3 first? Let's just do that, 1 or 3.
I do.
Okay,
So on one, because it's been gutted and amended, and we previously had the position,
We haven't had a position on this.
none currently, so we just, there's nothing really to do there. We
Right,
just write that
right.
window by. So
Right.
Procedurally, we just.
he'll bring
go
it
by.
back,
I'll bring it back
next
August.
month.
And we're coming back to two, I assume, and number two, going to,
Number 3 is, again, we don't currently have the position, and Phil's suggesting we remain neutral.
the recommendation is neutral.
So
And then-
we don't have to take a vote or anything.
Oh, so we don't, so in that case, we just don't take a position.
We just don't
and
take a
it's
position. It
a
just stays where it is
statement
now.
of itself. Okay. And because we'd previously taken a position with respect to AB 2523, after we hear from the commission and the public, you want us to vote on a new position, new recommended position.
Sure.
And so at this point with AB 2523, a number of things that we talked about at the last hearing, you said, have been addressed, where the default enforcement is going to be, which is a huge thing, which may be a battle we're not so happy we win, if in that sense. I mean, that's more work to do and more challenges, but it's the appropriate place for it in the PRA, and the appropriate backstop being us, with the local jurisdictions entirely having the ability to set their own numbers and then take over enforcement. So they still have the local control option, particularly with the enforcement, what I think is really key to maintaining some sort of local control aspect to this. And as the proponents had argued before, that the initial threshold campaign contribution limit is generous, so that, you know, I did make comment about, well, who's actually going to, there's sort of a normative issue about who's going to actually depart from that. But I think a lot of the things that we had brought up, particularly around enforcement, were our strongest concerns have been addressed. So I'm in a different position today.
Okay, any other, let's just focus on number 4 then, it sounds like. Any other questions or comments from the commissioners on AB 2523 contribution limits? Okay, is there any public comment on AB 2523 before we hear whether or not there's a motion? We did get a letter from the League of Women Voters, and I think we have a representative from the League of Women Voters.
Yes, thank you, Chair Remke and members of the commission. I'm Trudy Schaefer, representing the League of Women Voters of California. And of course, our letter was in response to the original staff recommendation. That letter asked that you change neutral if amended to support if amended, or support. And of course, those amendments, as our letter mentioned, have been made to the satisfaction of the commission. We've been in touch with the author's office and have seen the technical amendments that will be made once the legislature returns to the after the recess. And so we're very pleased that at least that step is in your minds as the recommendation and the decision for the commission. I would just like to comment in support of your taking a position of support, and that is based on the general reason for regulating campaign financing, and the fact that if we're looking at political equality for all citizens, combating corruption and the appearance of corruption, and combating undue influence, allowing maximum citizen participation in the political process, having contribution level limits does further those purposes, and we think that it's a reform that should be extended down to the local level. I note that, of course, as you've been speaking about, this is something that is flexibly written. It allows local jurisdictions to do as they wish, but it says that those that have been, in my mind, neglecting their best duty to the voters and citizens, in those areas, this quite generous contribution limit would take hold. And we recognize that the earlier amendments address the major concerns you had of it not being in the Political Reform Act, and of trying to figure out where the enforcement responsibilities lie. With the technical amendments, I'm pleased that you would be considering at least being neutral, but I believe that in fact, when you look at the size of contributions that are made in local races around the state and the fact that only a quarter to a third of cities and counties, that's saying nothing about districts, have contribution limits, this just seems like a logical step for you to make. It's a matter of increasing the public's trust in their democratic government. And for those reasons, I would urge you to consider support. Thank you.
Any other questions or comments from the commissioners for Phil on this one? If not, is there a motion for AB 2523 to move us from oppose unless amended? The recommendation is to go neutral. So really, just to take away our opposition. We're not going to be writing a neutral letter. Commissioner Wasserman?
So, as our speaker just indicated, she's asking about would we consider to go so far as support. And I'm just curious, with the amendments that have been put in place, why is neutral preferable to support for our purposes and for our mission?
Yes, thank you, Commissioner, for the question. When looking at the scope of the bill and the effect it would have on the commission, it's really based on a couple of issues. One, on uncertainty around the policy, and two, on fiscal and staffing. On the first issue of policy uncertainty, it is not an understatement to say that this is a huge growth in our jurisdiction. We will now be reaching into contribution limits depending on how many go default, how many jurisdictions become default into possibly thousands of local jurisdictions, affecting thousands of candidates and races. So it's large. The second issue is back to, we don't know how many jurisdictions will actually adopt, and so there's uncertainty of how many we will have default, what will be our workload. And the third is really in regards to training, because and education. We'll have to educate these jurisdictions on the fact that they all now have a state mandated limit. And part of the amendments isn't just the number limit, but there are a number of structural statutes, like what do you do when you're carrying over contributions? What do you do with general fund contributions that were given during the primary season? Things like that that are also coming over. And so there's a lot of training and education that we'll need to do, and so there's some uncertainty about whether or not we can do that in time with the staffing that we have, because it kicks in January 1st, 2018. It's being proposed to kick in during that time. And so it's the start of an election year, so you can see the difficulty in that. On the fiscal and staffing part, as you see from the staff report, our fiscal estimate is up to about $1 million. It's $1,070,000. And there's no guarantee that the legislature will increase our budget by approximately 8% in one fiscal year and authorize 8 new positions. And I can let Ms. Peth answer that specific issue.
Yeah, just to echo what Phil's saying, there's obviously sort of the timing issue in terms of when the bill would go into effect, but then also the overlap with the timing of the budget process. So obviously the state just started a new fiscal year right now, July 1st, and we would be then asking for 8 positions next year to implement this bill, and hopefully we would be successful in that effort, but obviously we don't know, and we'd have to go through the whole legislative budget process and make it into the governor's budget, and then also do the hiring that would be necessary to fill the positions, which obviously takes time as well. So, you know, again, should the legislature and the governor deem that this is good public policy for the state of California and it, you know, is part of our mission, then we would be happy to implement it. We just want to make sure we have the tools and the resources to do it effectively. And so, again, as staff, we just think it's best for us to be in a neutral position on this at this point.
All of those considerations in aggregate.
Thank you for that, because I thought that was very helpful for the record on this, because as we've just indicated, there were things that were done that were at our request and direction, but if we're still ending up neutral, there's some pretty strong reasons, and that's why I was saying that, you know, the achievement of getting those things responded to, maybe a victory or a negotiation that, you know, we have to may live with the consequences if the policy is determined that way. I had one actually sort of more substantive question about how things would work under this. If a local jurisdiction adopts adopts a contribution limit and an enforcement procedure. So that enforcement procedure, because there's a learning curve, has gaps, is empty in certain areas, leaves out things that would otherwise be covered if they were simply within our procedures. What happens? Other than they find they have something they don't know how to deal with, they cannot deal with, and they have to deal with it with further codes and rulemaking.
Yeah, the design that is being put in place when the bill is amended is if a jurisdiction adopts its own limit, the MPPC's hands are clean on that jurisdiction. We don't have any jurisdiction at all. And so if there are gaps in their enforcement, it would be up to
On
them.
limits,
On limits.
just to clarify,
That's right.
on limits.
Yes, not on disclosure and things like that. I'm sorry. Yes, but on limits. Yes, our hands are clean on the limit.
Right, enforcement of a local contribution limit. So they adopt a local contribution limit and they say, no, we want to go with the momentum of the direction and go lower than this number because we think this number is much too high for our little city or our little district or whatnot, which is, I think, was part of the hope of some of the proponents. But they adopt this contribution limit that takes it out of our jurisdiction to enforce, but then they fail to put together something that they can use to enforce. Is there going to be a mechanism by which, like when we do our review of conflict of interest?
I don't know if this completely addresses your question, but one of the things I have contemplated at least is that as a leader in the state on these issues, I think that we would probably put together just some sort of best practices. And I think you're asking specifically about the enforcement mechanism, but I do see part of what Phil was just talking about is some of the amendments that the author is putting in are important legal concepts to make limits meaningful. And I would see us sort of maybe putting together some sort of model ordinance or something so that one of the things Phil mentioned was, you know, the carryover from one election to another if you're running again, and how do you attribute funds back over to a new committee, things like that. I think to make this again effective and implemented as best as possible, I would think that we could be a leader and provide good service to these other jurisdictions. I think you're asking more specifically about the enforcement mechanisms, however, and as Phil was saying, if a local jurisdiction adopts their own limits, then it's up to them to determine how they are going to enforce it.
Yeah, and that's the clarification I wanted, but you also tied it into the other thing that just keeps coming back at us is the fiscal impact, because what we just talked about is, you know, I'm not sure what the positions you're contemplating are, but when we talk about enforcement a lot, the education process, the staff and technical are going to have to get out there and educate folks, etc. I mean, I really hope that if this does go forward as a policy, it doesn't become an unfunded mandate.
When we looked at the positions, we identified basically staffing needs throughout the commission in terms of education, legal, giving advice, and obviously in enforcement as well.
But I mean, I think to take another step, that Commissioner Wasserman suggesting that we'd actually be doing proactive outreach to these people who opt out of the default, more like a San Bernardino situation. I think this fiscal estimate is very conservative, and I think that would probably get us barely to the point of functioning, let alone doing extensive outreach. That's my assessment.
I just had a comment. I think I share the sentiment of the public comment letter, in that campaign limits are important, and there are some very small jurisdictions out there that you could essentially buy races. That said, there is obviously the practical aspect of this, and I hear it at our level, and that there's a cost associated with this, and that to do it right, you need to have the proper resources. I've also heard it at the local level amongst many municipalities who are struggling with the idea of having to deal with this. You know, if you do have a contribution limit, then they're going to have to monitor that and have processes in place to be able to do that. And I think so. As a commissioner of this commission, I understand the challenges that this would present to the FPPC, and I understand the neutral position might in some way provide us with some leverage perhaps to continue to push for further funding if this does come through, perhaps. So I recognize that, but I also wanted to be on the record just acknowledging the importance of that there should be contribution limits out there, and it's just a hard pill to swallow. That it's a good idea, but because practically it's difficult, we shouldn't do it.
Well, and I just want to reiterate, also current law allows local jurisdictions to adopt limits right now. So, that is available should a locality decide that that's where they want to go.
Yeah, and many have.
And this isn't brought by the League of Cities or the like asking for this mandate across the state. I mean, I think from my point of view, started way over on the left with opposed because of so many practical problems with it as originally drafted and not being in the PRA and the many problems. And I appreciate the author's office listening to our concerns and putting it in there, addressing some of the implementation statutes. But to get to support, which I agree with Commissioner Kasher, there's definitely a benefit to contribution limits. I feel like this is such a huge leap for the state and us. This bill was introduced in February. We've been scrambling to even get it into a shape we could take a neutral position on, let alone start to digest the policy behind it. I mean, I think there are a lot of policy questions about a one-size-fits-all default to 4,200. Does that really achieve anything other than a lot of time and money spent, like I say, scrambling to get things in place? I mean, a lot of cities that have adopted are much lower than that. So I'm not sure that the amount of time and money we've hit the right target here or the right approach. I mean, again, even some of the literature provided by proponents talks about other states that have these, and there's limits based on jurisdiction sizes. I mean, there's just other avenues that I know. I haven't been in any policy discussions regarding them, and I haven't heard them at the legislature. So I just feel like, to me, this is moving too fast for such a big issue. And that's why I would not move to support at this time. Anything else? Okay, so is there a motion to remove? I'm gonna make the motion and call it a motion to remove our opposition unless amended.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Remke.
Yes.
This motion passes.
Okay, so as far as the four seeking with recommendations, the last one is number 2, AB 2002 Stone Lobbying California Coastal Commission. We currently do not have a position. The recommendation is oppose unless amended. So you want to tell us a little bit about this?
Yes, Madam Chair. This bill comes to us from Mr. Stone after I think what Commissioner Wynn may have been hinting at is some news stories that came out about the Coastal Commission. We've been in contact with the author's office about our concerns. We raised some concerns at the last, or at least identified some concerns in the agenda in the last hearing that the commission had. And those concerns are stated in the staff memo about our taking on for the first time quasi-judicial proceedings, which are very different from quasi-legislative and administrative actions and even legislative actions, just in nature and in process. And it's not just quasi-judicial for the entire state, it's for one specific agency. And in order to address that one specific agency and their processes and culture, the author has put in a couple of carve-outs that are also problematic in the bill, one of which is to identify that Coastal Commission staff are not agency officials as it relates to lobbying. This will be the first time in the act that staff is excluded from agency official when being lobbied. And the second is to say that employees of a local government seeking within the scope of their employment with that local government to influence the actions of that agency also don't have to register as lobbyists. And Mr. Stone has identified that as something that is unique to the Coastal Commission. And so for those reasons, we have an issue with the carve-outs. Mr. Stone knows that. He also knows that we, at this point, staff is not comfortable with taking on quasi-judicial for just one agency without a broader look at the ex parte communication exemption with the Coastal Commission. and so we've communicated that with him and even gone so far as to suggest that because the Coastal Commission is so unique in its processes and its structure and its culture that he could structure something like the PRA within the Coastal Commission and the Public Resources Code and still get the same result that he's looking for. We haven't heard back from that proposal, but until we do, we're asking that you oppose this bill unless amended.
Commissioner Wynn?
So, I read your report, and Mr. Ong, I think you did a great job kind of summarizing what the law is, what the bill does, and what potential problems are. So my heart, began racing when you said, we've spoken to the author and he's willing to take amendments, because I do think that there is a problem, and at the Coastal Commission, and I would love to see, a legislative remedy, and I'd love for us to be on board. But I respect the concerns that you've got. I hope that you will continue to work with the legislative staff to see if we can, come up with a solution that fits the problem. And just want to encourage you to keep working at it.
Any commissioners? I will. I also appreciate the report and the concerns raised. I mean, as Commissioner Wynn said, I understand there's problems or concerns at the Coastal Commission. I wouldn't say that the Coastal Commission is so unique and so different than every other commission and board in the state that it needs a special carve out. And again, I think that's the concern I have here. I mean, I have a very big concern about going down the road of quasi-judicial as lobbyists. I don't think that has been looked at carefully at all, and who that would include. We just talked about lobbying and getting people to register and how difficult it is and tracking time. And if we start taking on quasi-judicial proceedings, I just don't even understand what the goal is there. As you mentioned, the Coastal Commission has an opportunity to address its issue, which is apparently unique to the Coastal Commission regarding the ex-parte communication and the like. I think for the Coastal Commission itself, as you mentioned in your report, to take a vote that says they should stop ex-parte communication, but then at the same time we're all scrambling to find a solution around ex-parte communication, really means something isn't right here. I mean, they're acknowledging the problem with that. And that is the problem. So, and I mean, as much as I disliked AB 1200 for a year and a half, I dislike this bill more. I think it has greater concerns. I really do. I think it's a broader problem if we really open this door to quasi-judicial for one agency, and then even within that agency have carve-outs. I think Ms. Peth pointed out to me that, for example, the Department of Consumer Affairs has 53 boards and commissions that fall under the ADA and have these kind of hearings. So when are we going to, every year are we going to hear another problem that we're going to add as quasi-judicial and then make carve-outs that are particular to them? I just don't think this is the answer. And my last point is, and I don't think it's a solution to anything, because like AB 1200, the Coastal Commission already does have provisions within its own jurisdiction regarding if you're going to appear before it, you have to file a notice of who you're representing and every interest you're representing. You have to have disclosures regarding your ex-parte communication. If those things aren't working, what possibly makes people think that registering as a lobbyist at the Secretary of State on a quarterly basis is going to solve anything?
Yeah, those issues were brought up with Mr. Stone's office, and I even think Mr. Stone, I believe, yes, I remember that he admitted that he'd be willing to amend it and put some of this and put all of this structure within the Coastal Act if he had time, because it's the second year of the session, and so they don't have time. He's feeling some interest group pressure to get action on the Coastal Commission now, and so that is why we're at this crossroads and not able to work out the amendments that in the time that we have liked. So
But as we said before, we can't be a one-stop fix-all for everyone and every problem, especially if there is no even clear analysis how this solution would fix any problem they're claiming to have.
Right, and just you brought up AB 1200, and part of the justification for our opposition for AB 1200 is, at least for me, I'm flattered that people believe we can solve all of the issues in the state when it comes to every issue, process, commission, it shows the trust that the state and the voters have in us, but we just can't be the solution for everything.
Yeah,
Everybody.
it's like address the problem, don't just give a, what appears to be a fix. But so I wonder if there are any other questions or comments. Is there a motion?
So right now the recommendation is opposed unless amended.
Right.
That's correct. I would move to accept that recommendation.
Are you making a motion?
Yes.
I second. Okay.
Adopt that recommendation, I should say. Not accept.
Commissioner Adaro?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes.
This motion passes.
Okay, any other questions or comments on any of the remaining legislation? Okay. Thank you. The last item, executive staff reports. Before we ask or have any questions or comments, I just want to highlight and thank the External Affairs and Education Division under Tara, and of course legal under Hyla. We talk a lot about enforcement and what they do leading up to an election, but as the report highlights, all of staff and those divisions in particular really have a huge task leading up to an election and helping people out. And I was just talking yesterday about the uniqueness of our agency, which really is from start to finish. We're not just about hammering at the end when there's a problem. We really are about encouraging compliance and helping people understand their obligations under the act. And so I want to thank staff for all their work. I know it's been a lot of extra work when there's the primary and gear up again for the election. So thank you. Any questions or comments on the staff? Commissioner Wynn.
Yes, thanks very much. So under pending litigation, Ms. Wagner, the Burgess matter, you said was going to be filed for hearing on July 12th, and I wonder if we have a hearing date.
We do have a hearing date. The hearing will be August 19th, Friday.
Do we meet that day? The day after we meet. Thanks. Yeah, really. I'll bring it up.
Any other questions or comments on the staff report? Okay, those will be submitted, and I'll move to adjourn.
Second.
Commissioner Adaro?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes.
Motion passes.
$1 money laundering case on the agenda. Congratulations.
Yeah, thanks. You're working with,